Both employers and unions engage in multiple different types of speech in the context of union organizing. To balance free speech protections with the goal of ensuring fair union elections, NLRA Section 8C states that speech is lawful unless it contains a threat of reprisal or force or the promise of a benefit. The NLRA prohibits coercive or threatening speech. Here are some examples. A union was attempting to organize an automobile manufacturer's workforce. Maria, the plant manager, required all employees to attend a mandatory meeting. Maria told employees that if the employees unionized, the union might call a strike. She said that the threat of strikes might deter customers and discourage outside investment in the business. Maria also said that if the company and its employees couldn't work together, the business might not exist in 10 years. Were those statements lawful? This kind of meeting is known as a captive audience meeting, which is a mandatory workplace meeting in which the employer speaks against unionization. An employer may lawfully hold such meetings without giving the union equal access to employees. Consistent with Section 8C, however, the employer may not make threats or promise benefits during such a meeting. Although threats are prohibited, predictions aren't. An employer makes a lawful prediction if the employer's speech addresses consequences that the employer reasonably believes, based on objective facts, are inevitable for reasons outside the employer's control. Here, Maria's statements were probably lawful. She expressed an opinion about some potential consequences of unionization that would be outside the employer's control, namely the risk of strikes deterring customers and investment, as well as the risk of such disruptions driving the employer out of business.